Supreme Court abused its discretion.
So I was really taken by your argument, and how could you possibly argue that the statement in the order of commitment, which states forthwith, first matter for argument is People v. Lantigua Gibbs. Whenever you're ready.
Good afternoon, Your Honors, and may it please the Court. Anaga Sundarajan for the appellants, the Office of Mental Health. Supreme Court abused its discretion.
So I was really taken by your argument, and how could you possibly argue that the statement in the order of commitment, which states forthwith, that term, forthwith, last paragraph, the New York City Department of Corrections shall forthwith deliver the above named defendant. How could you state that that's equivocal, or somehow we wouldn't know what forthwith means?
Certainly, Your Honor. So to be clear, our argument is that a contempt order is places a very specific burden on the party seeking contempt, and it incorporates a clear statement rule.
And forthwith is not a clear statement?
It is not adequately clear.
So what should the judge have stated in order to confer the wish that the defendant be sent to a psychiatric facility immediately?
Certainly, Your Honor. So the judge could have done a few different things here. The first is the judge could have included a deadline within her order itself, saying—
And if that would have happened, you wouldn't have been able to meet that anyway, right?
No, Your
As
Honor.
it still took you, how many days? It took you like 3 or 4 days? How many days?
6 months.
6 months. 6 months, I'm sorry, 6 months.
So forthwith means 6 months?
No, Your Honor. The
What
point—
does it mean to you?
So we agree with the appellant that forthwith does contemplate and imply a level of immediacy.
Well, doesn't it order you to do that with some immediacy, not just imply it?
No, Your Honor. The term in the order does not satisfy the clear statement standard for contempt. Now,
What happened if the judge had told you to do it within a month? What would have happened here?
of course, OMH would have endeavored and done its best to make sure that it met that
Okay,
order.
so again,
had that-
forthwith seems to convey some type of immediacy, even if you disagree as to the immediate immediacy. 6 months?
So, Your Honor, a couple of responses to that. The first is, with respect to Your Honor's original question, the other things that the judge could have done is amended the order to direct a faster transfer. Additionally, as we explain in our brief, the issue here is that OMH is facing very severe resource
Yes,
constraints.
so
It
did
could
you
not-
at any time go to the court and say, look, we're facing these issues, we have a shortage of facilities, we have a shortage of beds for females. Did you at any point do that?
We did that in response to the order to show cause, Your Honor, and additionally—
And that was 6 months later?
To be clear, what happened here is before the return date on the order to show cause, Ms. Gibbs had already been transferred because she was transferred as soon as a female bed became
But again,
available.
we're talking about 6 months, right?
Yes, Your Honor.
So during that 6-month period of time, prior to the order to show cause, did you at any point go to the court and say, look, we're facing these issues, we don't have beds for females, and so therefore we cannot comply with your order, and so therefore we need additional time or anything of that nature?
No, Your Honor, but there's not a clear procedural mechanism in a criminal case for OMH to do that.
And counsel, in fact, the shortage of beds was well known to your organization well before this case, right?
Yes, Your Honor, and
For about 2 years leading up, you knew that you were running out of space.
and OMH had done several things to increase its capacity. As we cite in our brief—
What did you actually do to increase capacity? Not the plans that you cited, but what was actually done?
So OMH had opened the additional space at Central Manhattan. Additionally, OMH has been lobbying the legislature, and the legislature is responding. So there is construction underway at Mid-Hudson for an additional facility. The governor's current proposed budget also includes funding and allocation for an additional construction.
So while all of those things are happening, what happens to individuals who are waiting to be placed to get treatment that they need?
And they're waiting at Rikers Island.
Yes, Your Honor, they are. And with respect to those individuals, respectfully, there's nothing more that OMH can do. OMH places them on, OMH designates them to a particular facility. Its current practice is to designate them to all facilities in the state that are appropriate for that individual. In this context, it is a secure facility with a female ward. It is constantly monitoring the situation, so if it can move people around or move.
OMH has a statutory obligation to review what demands there are for its services and address them proactively, correct?
It has, yes, Your Honor, and it has done so and met that statutory obligation here. And
Well,
again,
I mean,
contempt.
I'm not curious as how you can say that. At the time that the defendant was designated to Mid-Hudson, apparently the record shows that there were 61 individuals, I'm assuming females, pending admission in front of her. So, so how is it that you recognized what the issue was and you attempted to remedy that situation? She's on a list, she's 62,
Because
and there's no argument that she was not in need of psychiatric treatment.
That's correct, Your Honor. OMH did everything in its power. OMH, as a subdivision of the state, obviously cannot compel the legislature to allocate additional funds. It also cannot oversee or require Rikers or the city to take additional steps.
But you have an affirmative statutory obligation to assess what your needs are and to proactively plan for those needs, correct?
Yes, Your Honor, but contempt is a very specific remedy here. And here, contempt is inappropriate in these circumstances, as the Court of Appeals decision in Eldeden and others that we cite in our brief make clear.
You have
This,
time
of course,
on,
does
you have
not-
time on rebuttal. Thank you.
Thank you.
Yes.
May it please the court. Jennifer Hose of the Legal Aid Society on behalf of Ms. Latika Gibbs. This court should affirm the Supreme Court's decision holding the Office of Mental Health in civil contempt for failing to admit Ms. Gibbs to an appropriate psychiatric facility for restoration services for over 5.
Justifies the $1,000 penalty.
Your Honor, at the time when Judge Neubauer issued her decision holding them in contempt, she was well aware of the fact that Ms. Gibbs had been subjected to an additional 180 days of incarceration based on the failures and inaction of the Office of Mental Health. She had within her power the ability to order a monetary fine to compensate Ms. Gibbs for that
How do you
injury.
determine the amount of the fine?
There have been different courts who have determined damages without there actually being proof of actual damages based on prolonged incarceration. And this,
Also, did you provide any evidence to quantify the losses or possible injuries that she suffered?
the evidence that was provided to the court was the numerical amount of time in which Ms. Gibbs was suffering without having this court-ordered mental health treatment while she was on Rikers Island, which is, of course, one of the worst places for somebody like Ms. Gibbs who is suffering from mental illness based on the well-documented.
Right, but the question is, was there anything provided by you as to how that 180 days while she's awaiting admission to a psychiatric facility, how that translates to $1,000?
There was no evidence that was provided based on the actual damages. However, courts in many cases that I've cited in my brief are able to render a decision as to compensation without proof of actual damages. Here, the court was well aware of how long Ms. Gibbs had suffered. They ordered a modest fine based on the injury suffered to Ms. Gibbs. Ms. Gibbs's case was the only one that was before the court. It was based solely on Ms. Gibbs and what the court felt was appropriate. And the court had ample evidence in its record to compensate Ms. Gibbs for the injury that she did suffer.
Are there
in this
other
case.
cases that are comparable in terms of duration where no actual evidence was provided as to that individual and courts awarded a contempt fine in this amount?
The cases that I do cite in my brief are not in the context of a contempt finding. However, they are federal cases in which someone was subjected to only a few days of incarceration, and they were damages up to $10,000.
Right, but there was a calculation as to what the damage was per day in those cases.
But in those cases, there was no proof of actual damage that was submitted to the court. Here, this was a modest fine that Judge Neubauer issued based on the injury that Ms. Gibbs did suffer, which was very clear in this case. Judge Neubauer found that not only was she prejudiced, but her rights were violated, and that her case was ceased. She had no right, based on the mechanisms in CPL 730, she had no ability to seek any sort of due process. She couldn't seek release.
Right, but again, the problem is, or the issue is, how do you attach a monetary value to that? I mean, the statute talks about $250 plus whatever other showing there is, and so therefore it would seem to be the baseline would be 250, and then after that you would have to make some showing as to how the 180 days, how you calculate some type of monetary damage for those 180 days.
Well, she did know that she was incarcerated for 180 days and 250 being the baseline. And so $1,000 does seem to be in line with the prejudice that Ms. Gibbs did suffer, and that and it was a modest fine in comparison to other cases in which somebody is subjected to prolonged
So in
incarceration.
terms of the contempt finding, what was OMH supposed to have done during that 6-month period of time? I mean, recognizing the lack of facilities for females, lack of resources, et cetera, what should they have done? Or what could they have done?
The record the Judge Neubauer based her decision on the record that was before the court, where OMH failed to really show any sort of evidence that they had responded to this trend that their own data had shown had been happening since 2015. Rather, they simply, through their affidavit that was submitted from BITS director Matthew Schatzel, it essentially shows that they had just accepted that people were going to have to suffer these significant waits, and that there was going to be a wait list because they always operate at capacity. This is an issue that they had been aware of since 2015, and as Judge Neubauer said, they were aware of it based on their own meticulous record keeping, yet it did not command their full attention in a way in which it should have.
Well, their argument is that, go ahead.
I was curious whether, certainly there are some government agencies like homeless shelters that end up renting parts of a hotel to deal with overflow issues. Does OMH ever do that?
OMH consistently feels as though every person who has an order of commitment must be at a secure facility, and so they operate the secure facilities that are currently at capacity. Judge Neubauer did explore with the Office of Mental Health during her arguments whether they could repurpose certain facilities to accommodate the need, and it was clear based on the answers from counsel that that was not something that they had explored. And so the record in this case was really about the fact that the court found that forthwith was a clear and unequivocal mandate. There was a lack of any sort of evidence or submissions by the Office of Mental Health to show any sort of efforts that they had taken to make it so this wasn't a problem of this making that would lead to Ms. Gibbs and others similarly situated having to wait for close to 6 months at Rikers Island before they had that treatment. The question before the court was a narrow scope of whether contempt was appropriate, and there was ample support in the record to find that it was. And so I ask that Your Honors affirm the decision.
Thank you.
3 quick points, Your Honor. The first, with respect to Your Honor's question about alternatives for OMH. Because Ms. Gibbs was charged with a violent felony, she could not be placed anywhere other than a secure facility without consent or approval from the district attorney. And so,
Was that sought?
no, Your Honor, for a couple reasons. The first is, with respect to OMH, that consent needs to be provided before the order is entered under the procedure laid out in 730.
Was the court ever made aware of this? Was the court or any court ever made aware of the fact of the issues that OMH has in terms of these facilities?
I'm not sure, Your Honor. However, it is a well-documented issue. Like I said, the legislature and the governor have been...
And the proposals that you have, that you state that OMH, was endeavoring to make these changes, et cetera, they seem to be long-term, right? And you need legislative approval, you need construction. What about in the short term? Was there anything proposed or done in the short term? My colleague mentioned repurposing, anything of that nature?
So with respect to secure facilities, repurposing is itself a long-term project because under Section
Must be
33020,
faster than building from scratch, though.
it is, Your Honor, and that's what was done with Central New York Psychiatric. OMH is considering others. However, if it repurposes an existing hospital ward, that of course
So
removes.
I'm assuming there's also a wait list for males?
Yes, this is a wait list across the board because secure facilities have to meet certain statutory requirements under both state and federal law.
I thought that I saw on the record that there was a wait list for females, and at some point in time, she was on a wait list for females specifically.
She was specifically on a wait list for females because these are gender segregated wards.
Right.
There is a wait list for males for the wards.
So is there any, so you could not repurpose a male ward for females if you have more females on a wait list than males?
Not without moving the men in that ward out of it and finding another placement for them, Your Honor. That is the problem here. And OMH, of course, can't
So
control
I'll
how
give you
quickly.
a second, a minute to address the issue as to the fine.
Certainly, Your Honor. So as we explained in our brief, civil contempt has two purposes and neither of them was satisfied by the order here. As we noted, she had already been transferred before the return date for the order to show cause, so there's no need to compel compliance. With respect to the fine, on the face of the order, the trial court was not endeavoring or contemplating compensating Ms. Gibbs for anything. Rather, the trial court says very explicitly that the fine is meant to deter and to punish. That is inappropriate for civil contempt, and at the very least, this court should remand for the court to reconsider that, especially because the court made an explicit finding in its order that there was no willfulness necessary to support a finding of